Hello, everyone. My name is Mariah Kruger. I am the Housing Program Manager and Resource Attorney at Volunteer Lawyers Network, and I'd like to welcome you today to our training on the Eviction Expungement Basics. Before I get into the content of my presentation, I wanted to start with two housekeeping issues. First of all, for those of you who are attending live today on September 23rd, we're going to write the CLE code into the chat function so that you'll be able to see that. Also, we ask that everybody who is in attendance write your name into the chat box and send it. It won't go out to everyone in the group. It will be kept private, but we will keep track of those names for CLE accreditation purposes. With that, once again, I want to welcome you to our presentation today here on the basics of eviction expungement. We're doing this training both live and then we'll be taping it to put on our website in the hopes that this is going to be a good training for those volunteers who are interested in taking a full rep eviction expungement case but haven't yet done so, and also a good training for those people who are doing our phone advice clinics. We do get a lot of people through our phone advice clinics with eviction expungement questions, and this training will be a good training to help our phone advice attorneys answer those questions. Next slide, please. So today for our training, we're going to talk about the impact of evictions. Just want to make sure that everybody has a good understanding of the importance of eviction expungement work and the effect that it has upon tenants. Then we're going to jump into the legal standards that courts will look at when they're deciding whether or not to grant an eviction expungement. And then we'll finish up by talking about the eviction expungement process, the drafting, filing, what courts are doing for hearings here in our pre-COVID or post-COVID world, excuse me, and then we'll talk a little bit about post-hearing issues. Next slide, please. One thing I want every volunteer, in fact, I want every Minnesotan to know, is that an eviction is on a tenant's record the moment that eviction is filed. Doesn't matter what ultimately happens in the case. If the landlord files that eviction and then the tenant reaches out and pays, the landlord says, hey, we don't even need to go to court. I'll just ask for it to be dismissed. The landlord goes to court, gets the case dismissed. That eviction record is still on that tenant's record. Let's say that the parties do end up going to court, and at court the plaintiff raises a service issue or some other defense and the case is dismissed. If that tenant doesn't affirmatively ask for that expungement or that record to be expunged from their record, that eviction record still exists. Same case if the parties even take it all the way to trial and the tenant wins. If the tenant doesn't know that they need to affirmatively request that that expungement be that eviction be expunged from the record, the eviction remains. There are some good questions about how long do eviction records remain? And the answer is essentially indefinitely. However, there are a couple of rules that we want to make sure our volunteers know about. First of all, tenant screening agencies that are regulated by the Fair Debt Collection Practices Act can only report debts for up to 7 years back. So eviction records that are older than 7 years, those tenant screening agencies that are regulated by the Fair Debt Collection Practices Act couldn't report those. So there is sort of a spot at 7 years where less evictions are being reported. However, right now within the court system, there is no date at which court records disappear. The courts do have a document retention schedule, which they may or may not choose to file, but there is no point at which an eviction record will just disappear from the court. So even if an eviction is 10, 12, and even 14 years old, if someone wanted to sit down at Mincis or go into the courthouse and do a record search of a name, even those very old records will still show up. And we do hear from tenants every once in a while about very old eviction records that are still causing problems. The other thing I wanted to let people know about is both Minneapolis and St. Paul have passed tenant protection ordinances, which do limit landlords' ability to screen for evictions to some degree, both in Minneapolis and St. Paul. The Minneapolis ordinance is now in effect for landlords with over 15 units, but won't be in effect for all landlords in Minneapolis until December 1st of this year. The St. Paul ordinance is even newer. It has been passed by the city council, but it's not in effect yet. It'll come into effect in March of next year. But that will give tenants some more protection from old evictions on their records, at least for those who live in Minneapolis and St. Paul. One of the really important things I also want people to know about evictions is that an eviction is an extremely black mark on a tenant's record. It's the big red A on someone's shirt. And while years ago, when the vacancy rate in housing wasn't as low as it is, an eviction maybe didn't have as much of an impact as it does today. But today that impact is tremendous because of the low vacancy rates in rental housing. And those vacancy rates are particularly low when it comes to affordable and low income housing. While the vacancy rates have improved somewhat for higher income brackets and in rental in those areas, for apartments that are being rented at 30% of the area median income, the effective vacancy rate is still 0. So having something like an eviction on your record makes it even more difficult to find housing in an already extremely difficult market. One other thing I want people to know is just about the disparate impact of evictions. Pre-COVID, when we were having eviction calendars at court, one could just walk into the housing court and immediately notice the disparate impact. Why the statistics we have on this slide here are quite old, from 2016. I still think it tells the story that we need to tell. And that is, it says in 2016, 50% of residents in 2 zip codes, 55411 and 55412, and those are the North Minneapolis zip codes, had experienced an eviction in the previous 3 years. Another thing I think is interesting is there were 10 property owners that made up 25% of all eviction filers. And I have to say, for the most part, there are good landlords out there that don't want to evict people and use it as a last resort. But there also is sort of a black market for evictions out there. And I think if people haven't read Matthew Desmond's Evicted book yet, it is a fantastic story that really helps people understand some of the black market forces that go on in the housing market. One thing I think is interesting to note, and that Matthew Desmond points out, is that those people who are renting properties that are from slumlords, poorly maintained, aren't necessarily paying less for their properties. And in fact, they may be paying market rate or even higher market rate. And one of the things is eviction can become a cycle. So let's say that someone is rent burdened, and rent burdened means that they're paying more than 30% of their income for an apartment, which is extremely common for people to do. Then something happens, a death, a sickness, a car breaks down. I'm always surprised at how many people fall behind on rent because they had a family member die and they've chosen to pay funeral expenses as opposed to their rent. So that falling behind on rent eventually leads to an eviction for non-payment of rent. When someone's been evicted, they now have an eviction on their record and they have to find a place in a relatively quick period of time. In a market such as the market that we have, it really leaves tenants in a bad position. So they're forced to find rental housing as fast as they can. And that's where the idea of these slumlords come in, people who take advantage of people who are at a crisis point. So someone who's at that point rents places probably not in as well repair as it should be. They get in there, they complain about the repairs, the relationship between their landlord, who's not really doing the job that that landlord should be doing, disintegrates, and another eviction comes on that tenant's record. Now it's a tenant with 2 evictions on their record, and they still need to find a place to live in a relatively quick period of time. So you can quickly see how evictions can become a cycle for tenants, and how there really can be some nefarious market forces out there that are taking advantage of people who aren't able to rent from the quality stock of rental housing. Next slide, please. With that background, I want to jump into the legal standards for eviction expungement. So we'll be looking at those standards that a court takes into consideration when determining whether or not an expungement should be granted. There are essentially three different standards. The first standard we're going to talk about today is the mandatory authority standard, and that comes from statute. The second standard that we're going to talk about is called the statutory authority, and it's also granted by statute, but it's discretionary. It's not mandatory. And the third standard that we're going to talk about is the standard that comes through the common law. Next slide, please. I think we have just an issue on our slides here. Can we get to the next slide, please? And while she is moving to the next slide, I will start to talk about mandatory authority. So mandatory authority, and I talk about it first because it's probably the authority that we see the least, but it's still important that people know about mandatory authority. Mandatory authority, it comes from statute. It's Minnesota Statute 484. .014. And this is the standard that comes into place when there's been a cancellation of deed or a mortgage foreclosure. Once again, we don't see a lot of these, but they are mandatory authority. So if the motion for expungement properly pleads underneath these standards, the court must grant that expungement. And really it has to do with notice to the tenant to make sure that they were given notice at the appropriate time, and if they had left prior to the beginning of the eviction action. If you ever do see a cancellation for deed or mortgage foreclosure in an eviction case from us, you'll want to pull out the statute and carefully take a look at it. However, because we don't see that much of these, I'm going to move on quite quickly here to those authorities that we do see in most of our cases. Next slide, please. So statutory or discretionary authority is our next standard, and this one also comes from Minnesota Statute 484.014. This lays out a three-part test in which the court can grant an expungement in their discretion. The test is a three-part test, but it's really a faux three-part test, I would say. It's really two tests. The first test is the case without a basis in fact or law? So what this test is looking for is there a reason why the court should have found for the tenant at the time that the case was brought? Are there defenses that weren't properly raised or missed by the court for some reason, such that now upon looking at this case later on, we can take it off the tenant's record? The second part or the tests 2 and 3 under the three-part test, or the second part of the consolidated, is the justice argument. And here it is important for the court to look at whether or not justice, the interests of justice require that this eviction be expunged. Another one is, are the interests of justice outweighed by the public's interest in knowing about the expungement? And like I said, I think we can put these two together. Even when we plead them in our documents, we still need to plead them separately. But really here we're just looking at, does our sense of justice say that this record is no longer important to have out there because it no longer adequately reflects on the tenant's ability to be a good tenant? Next slide, please. So for the statutory authority or the discretionary authority before the court, we're going to spend the next bit of time talking about whether or not the underlying case is without basis in fact or law. So this really requires looking into the defenses in an eviction case. I'm not going to go over all of the defenses today. There's a long list of defenses, and Larry McDonough on his Poverty Law Homestead website has a very good answer form, and it's check the box in which all of the different possible defenses are listed there, and one can take a look at an eviction case, talk with the client, and really just check all of the boxes that apply. Eviction expungement is a slightly different procedure, and it's at a slightly different time in the case. So what I've tried to do is narrow down those defenses that I think are the most effective defenses to raise at the eviction expungement level. Next slide, please. And with that, I'm going to start with proper service. And I think in every eviction case, we need to look at whether or not service was proper. Couple of reasons for that. First one is that there's a Supreme Court case out there that says that service must be strictly complied with. There must be strict compliance with that service statute. So we really do need to look carefully at how service was done. Second reason is there are services not extremely straightforward. There are a few tricky parts in service where certainly landlords who aren't attorneys or with their first time through housing court, it is easy to not do service correctly. On another note, I'm just going to list here in general, all service must be completed 7 days at least prior to the hearing, and service is governed by Minnesota Statute 504B331. Next statute, please, or next slide, please. There are essentially 3 ways in which landlords can affect service in eviction cases. They can do personal service, they can do substitute service, and they can do alternate service. So when you get a case from Volunteer Lawyers Network, either from phone advice or a case that you decide to take full rep, we will provide you with all of the underlying documents. So you'll always be able to see what type of service occurred. We always want volunteers to take a close look at those papers and determine if there were any errors. If there is one service document for each tenant, we know that service was either completed personally or through substitute service. If there are 3 or 4 service documents, we know that the landlord attempted service through alternate service. We'll start by talking about personal service. So personal service is when someone who is not the landlord, it needs to be someone who's not a named party in the action, knocks on the tenant's door, sees the tenant, hands the tenant the complaint. And it needs to be a personal service. It can't be slipped underneath the door or simply mailed if you want to effect personal service. It needs to be a handing of the document. It's also the landlord or the named party cannot be the person who serves that. It also should not be someone too closely connected to the landlord. It shouldn't be the landlord's spouse or partner. It shouldn't be a child or sibling of the landlord. There is a bit of a legal question as to like a maintenance person or someone who works in the landlord's office, but I think the best practice would be to use someone completely disinterested to complete the service process. Second type of service that could be done is a substitute service. The substitute service means that whomever the landlord was using to effect service knocked on the door, and it wasn't the actual tenant who opened the door, but it was someone else. Now, a landlord can hand that document to a person of suitable age and discretion who also resides at the property. This can't be grandma who's visited from Arizona and is staying 2 weeks. Can't be the babysitter, and it can't be the teenager's boyfriend who just happened to be there that afternoon. It needs to be somebody who resides on there, resides at the unit. We most commonly see this where there are 2 tenants and both tenants need to be served, and only one tenant is personally served, and then the second tenant is served through substitute service to the first tenant. So when you get the service documents and you're looking over these, if you're talking with the client at the same time, some of the questions that you'll want to ask are, were you served? Do you remember receiving the document? Who gave you the document? Did you know who that person was? If there's substitute service, you'll want to ask, did that person reside at the property? Who is it? Did they actually receive the paper? And these are all interesting questions because more common than you'd think, these defenses do come up. When we look at alternate service, once again, we're going to have those 3 or 4 papers. It's most best to have 4, but alternate service needs to be that there have been 2 personal attempts made at service. One has been between the hours of 6 and 10 p.m., that a copy of the summons and complaint has been mailed to the tenant's last known address, and that an affidavit of not found and the affidavit of mailing are filed. And it's only after those documents are filed then can the landlord or the landlord's agent, whomever they're using to do service, go back to the property and post that sign, the eviction action complaint on the door. So what this practically means is that the landlord, in order to do service correctly through alternative service, needs to visit the property at least 3 times. 2 of those times are going to be to do personal service, and those, once again, separate days. One needs to be between 6 and 10 p.m. Then the landlord needs to go back to their office or get onto the Wi-Fi someplace if they're going to electronic file their affidavit of service, their affidavit of not found, and their affidavit of mailing. And it's only after all of those things are filed with the court, then can go back out to the property, post, and then file that affidavit of posting. Because of this, the 7-day rule that a service needs to be completed within 7 days, that posting needs to take place at least 7 days before the initial appearance, and affidavits of service should be filed at least 3 days before. So once again, if you have a case where there is alternate service, you want to look and make sure that there were 2 attempts on separate days and one of them is between 6 and 10 p.m. You're also going to want to take careful look at the date and time that everything has been filed. Everything filed electronically has a time and date stamp, so we can see if it was filed not only on Tuesday the 1st, but we can see if it was filed at 10 a.m. on Tuesday the 1st or 3 p.m. on Tuesday the 31st. And I say that because it is possible to do all of this within a 2-day period, although it usually takes longer. But let's say the landlord went out on Monday night at 8 p.m., tried to personal serve, not the landlord's agent. So went out to try to personally serve the tenant, was unable to, went back out Tuesday morning at 10 a.m. They can do that because they've tried once at 10 p.m., but they were also unable to successfully serve them. Then they went back to their office at noon, did the filings with the court, and then at 3 p.m. went back to the property, posted it, and filed that affidavit of posting that said that they did it at 3 p.m. That would be one sort of sequence that a landlord could get it done within 2 days, but once again, that landlord needs to have visited the property at least 3 times. And we do, because the sequencing is so specific and that filing needs to take place before the posting, we do see errors. The most frequent error that we see would be someone goes out to the property, does the first attempt at personal service, goes back to the property, does the second attempt at personal service, and while they're there, posts at the same time. So there hasn't been that filing of the attempts and the filing of the affidavit in between that last visit and the posting. Next slide, please. So the next thing we want to talk about is making sure that there is the proper plaintiff on the eviction action complaint. Statute is clear that the plaintiff listed on the complaint must be the person entitled to possession of the property or an authorized management agent. It's fairly easy to determine who owns or is authorized to possession of a property by searching property records. Certainly in Hennepin and Ramsey County, you can just go onto the county websites, find out who the owner of the property is. If the owner listed on the county sites is not the name of the plaintiff on the complaint, then further inquiry needs to happen. It is possible that landlords have an authorized management agency. There needs to be some sort of documentation of that agency, which is harder to prove at the eviction expungement expungement level. But I think if you see someone who's not listed as the property owner, that it is, and there's no reason to believe that the management agent would be the authorized management agent, that it is an important argument to raise at the eviction expungement. Next thing I wanted to talk about is having a proper power of authority. Now, Minnesota Rules of General Practice 603, the 600 rules only apply in Hennepin and Ramsey County. So this is something that we wouldn't be looking at outstate, but certainly here in Hennepin and Ramsey County. And those rules allow an unlicensed agent, a non-attorney agent, to represent landlords in housing court. But in order to do so, they must have a power of authority attached. So if you are looking at a complaint and the person who signed the complaint is not the plaintiff itself or an attorney representing the plaintiff, then you need to take a look to see who that person is. It is possible that it could be one of these non-attorney agents. If that's the case, a power of authority needs to be attached to the complaint. And powers of authority, for those, I guess we just want to make sure first that they're there when they're supposed to be, and then that it's the appropriate power of authority. Once again, we see more incorrect power of authorities than one would probably expect. Something for a different case, a different county, for a different person that's listed. But really, we just want to check to make sure that they're there and that it looks like the correct and appropriate document. If not, it's an important issue to raise in your eviction expungement motion. One other thing with regard to proper plaintiffs, it's not exactly a proper plaintiff defense, but it certainly falls within this area, is in the city of Minneapolis, they have a great ordinance which says that if a landlord is not properly licensed, that they can't collect any rent, which is a strong defense for a tenant to bring either at the eviction level or not then, certainly during the eviction expungement area. At the eviction expungement time, excuse me. And it's relatively easy to go into the City of Minneapolis webpage, property info, and look up rental licenses. And you should be able to see whether or not that landlord, during the period of the eviction, the records go back quite far, to see if they were properly licensed. Do have to say there is sometimes landlords who are properly licensed that do not show up on the City of Minneapolis webpage. But I think if you do look and find on the City of Minneapolis webpage that there is not a proper license at the time that the eviction occurred, that does authorize attaching a copy of what the search for the City of Minneapolis turned out and raising that as an eviction defense and allowing the landlord to come back and counter it, and if it's not true at that time. You know, other municipalities have similar rules. In the city of St. Paul, it's a certificate of occupancy. None of the other jurisdictions I'm aware of have a city ordinance quite as strong as Minneapolis, but certainly if you're interviewing your tenant and your tenant is saying things like, you know, my landlord was not authorized, it wasn't a normal landlord, you can always call the jurisdiction that the case is in and ask about the rental licensing and whether or not that property was properly licensed. Next slide. Another defense that is important to look at the eviction expungement level is whether or not habitability defenses were properly raised. So habitability, there are 4 covenants of habitability that may not be waived by landlords. And what that means is I can't make a deal for you and give you the room in the top floor of my garage, which doesn't have any heat and doesn't have any windows. And I can't just charge you $200 a month because it's really not all that great to begin with. Anytime in Minnesota, someone is renting a unit for residential purposes, it needs to meet all of these covenants of habitability. If a place is not in proper repair or does not meet the health and safety codes or is fit for the intended purposes, a tenant can raise that as a defense for non-payment of rent at the eviction setting. I can tell you it's best if tenants don't wait to be evicted if they're withholding rent and instead file a rent escrow action to get those repairs made. But the Fritz v. Worthen case did recognize the right of a tenant to say in a non-payment case that there were repairs, so therefore I didn't get what I had bargained for and I didn't pay the rent. Some things to know about when tenants raise that defense, however, if they do, they will be required to pay into court whatever rent is undisputed at that time. And this does act as a bar for tenants to raise this defense sometime, because if they're truly behind on several months of rent, in order to have a trial on whether or not repairs needed to be made, they're going to need to come up with that money and pay it into court. So if repair issues were in the underlying case and the tenant was unable to raise them because they couldn't pay into court, I think it's a really good argument to bring up at the eviction expungement time. Another time I think habitability claims are a good thing to bring up at the eviction expungement time is if for some reason the tenant didn't show up at their hearing. Maybe service wasn't good, maybe they had already left. But for whatever reason, the repair issues weren't raised. One situation I don't think it's a good idea to raise repair issues at the eviction expungement setting is if those issues were already raised and considered by the court during the original eviction action. So maybe the parties went to trial over the repairs, or maybe repairs were contemplated in the settlement agreement. Then I don't think raising repair issue without a host of other things along with it in your eviction motion is necessarily a good idea. Next slide, please. I think we want to talk about a good defense to look at in the eviction expungement setting is if the underlying eviction was for breach of lease. Couple things I want you to know about breach of lease. If a landlord is evicting a tenant for a breach of lease, that breach must be material. For example, noise. Did the noise rise to a level that the police were called out to the premises and had to break up a loud party on numerous occasions? Or was it noise of a crying baby or walking across a unit late at night? Evictions need to be material, and that's a fact question. Sometimes the underlying eviction case is going to get at that fact question, and it's probably not something that we're going to raise at the eviction expungement level. But if that wasn't fully considered, and that was one of the eviction was for that breach of lease, might be something that a tenant would raise at this eviction expungement level. Some other things about breach of lease that are important to know. The prohibited behavior and the consequence must be included in the lease, and that's for everything except for criminal behavior. So if it's smoking, if it's guests, if it's pets, those types of things, along with the consequence for having those types of things, need to be included into the complaint, or excuse me, in the lease. Also, the lease must be attached to the eviction complaint if the eviction is for breach of lease. So when we send you the documents for the underlying case, the lease should be included with the complaint. If you get the documents from us and there's no lease attached to the complaint, that means there never was a lease that was attached to the original complaint. Finally, it's the burden of the landlord to prove the breach. It might be a little harder to raise those types of issue at the eviction expungement setting, but I just want to make sure that you are aware of how the breach of lease works. Also, with regard to waiver, back to our noise example, let's say there was a noisy party in mid-February. The police were called out, they had to break up the party, sent everybody home, then tenant paid rent in March, landlord accepted rent in March, and then towards the end of March decided that they were going to file a complaint for this breach of lease of the noisy party. There could be a good argument there that the landlord, by accepting rent in March and allowing a significant period of time to go by, waived the right to evict by breach of lease. Next slide, please. Some other defenses that I want to make sure people are aware of, and one defense is that the tenant no longer lived at the property. Evictions are only about possession of the property. They're not about money. So if the tenant left the property and the eviction action was filed after that, there shouldn't have been an eviction filed in the first place. One thing to note about that, though, if the tenant leaves and the landlord doesn't know the tenant has left, the tenant hasn't turned in their keys, sent a letter, or somehow made it clear to the landlord, a landlord, if they don't know for sure that a tenant has left, cannot get back into the unit without the eviction process. So making sure there's some sort of evidence that it was clear to the landlord that the tenant had left. Another one that comes up more often than you'd think is a dispute about whether or not rent had been paid and how much rent had been paid. If the tenant comes back and says, you know, I know that they had been paid and maybe didn't receive proper service, so didn't show up at the hearing, or for some reason that didn't get fully heard at that time, I think that also is an important point to raise in your eviction expungement motion. Also, claims for a retaliatory eviction. If a tenant has contacted the landlord to enforce their rights, whether it would be for repairs, for things that were promised in the lease that weren't being given, for a reasonable accommodation, the tenant does have certain protections for asking to be able to enforce their rights under the lease, and an eviction too close to those times when the request to protect their rights was made place could lead to a retaliatory eviction. And there are many other defenses here that I'm not raising. But just when we're looking at like the idea of this case shouldn't have been brought to begin with, once again, we really want to step back and look at the overall picture. And what we do frequently see is it's not just one defense, but we might see, oh, there was a small problem with service, and then, you know, there was a question as to whether or not they were still in the property, and the property wasn't very well maintained, that all of a sudden we see that there are multiple defenses that could have been raised. So it is important to do the inquiry to see what some of these major defenses are. And if there are several, and I think once you start to throw them in, then do put them all in. I think it's more of a judgment call if you have just one smaller issue. And maybe, I'm trying to think of an example of maybe there was just one breach of lease, if it was a material breach of lease, or just maybe just the repair, that'd be a good example. If there were just the repair issues going on, is that enough to also claim that this case shouldn't have been brought? Or do we want to lean more heavily on the justice arguments and go with just an inherent authority argument instead? I'll talk about that a little bit more, but I just want to raise that now as we're thinking about both the statutory and inherent authority, which we're moving to next. So next slide, please. So I'm going to jump into inherent authority next, and you might be thinking, wait, you said there were 3 prongs in the statutory authority, and you've only talked about the mistake of fact and law so far. What about the other 2? Well, the other 2 prongs in the statutory discretionary authority are the justice argument. And the inherent law, or the common law inherent authority argument, is simply just the justice argument. So we'll talk about that next, and we'll look at that justice. But really, if that justice piece is there, you're going to argue it both in your, you'll argue it in your inherent authority argument. If you have done sort of the screening for all of the defenses in your eviction case, and you see that there was a reason that this case should not have been brought to mistake in fact and law, then you are going to plead both statutory authority and inherent authority. Okay, but you will always, at the minimum, plead the inherent authority or the justice argument. Just a little bit about the underlying authority for common law inherent authority. There is a Supreme Court case back from 1981 that said that the courts have in their expungement is in their inherent authority to grant for justice reasons. We also have a statute in 504B which recognizes the court's inherent authority ability to expunge evictions. Next slide, please. So whether or not the court on its own accord ever sua sponte expunges cases, it rarely happens. There is a document retention policy that the Minnesota District Courts have, which says that if a case is over 1 year, if an eviction case is over 1 year old and there is no judgment attached to it, that case may be destroyed. And if eviction cases have a judgment attached to it after 10 years, that case may be destroyed. The court, it's simply a permissive policy, and the court rarely follows this policy. There was about 2 years ago, the court went through a major purge and did get rid of a lot of old eviction records. However, there are still a significant number of old eviction records that continue. What we do find is that the document retention policy is a good argument to raise for cases which would be permitted for destruction through the document retention policy to raise under the inherent authority argument. Next slide, please. We also have some case law that lists some factors that one can consider, the courts can consider in the inherent authority justice arguments. The first one is at-home apartments is a newer case, but it is an unreported Court of Appeals case, and it's actually the concurring opinion. The case itself actually questioned whether or not inherent authority exists and went through all of the case law and said that there is no precedential case law out there for the inherent authority in the eviction expungement setting. The inherent authority for expungement cases law that's out there is for the criminal record setting. However, courts, at least here in Hennepin and Ramsey County and Anoka County, still do decide cases on inherent authority quite regularly, and they view that criminal expungement inherent authority as to also extending to eviction expungement. And we also have a slightly older, another unreported case which lists some of the factors that courts will look at. Next slide, please. So I've come up with my own little list from those that are given to us by the court. The one thing I do want to just a little bit of caution with those lists that were granted by the court. Those lists certainly aren't the only thing that will be considered under the justice argument. I think justice argument can be anything that sounds to you like could be a good justice argument. Some of the most important ones I think to look at are, on the first one is what happened to the underlying case? Was it dismissed or was there a judgment in the client's favor? So if the case essentially shouldn't have been filed against the plaintiff to begin with, and it doesn't quite fall under the statutory authority, it still can be raised as an inherent authority justice argument. Another thing we always look at is, was there a settlement agreement signed by the party and was that settlement agreement satisfied? If there's been a fully satisfied settlement agreement, I think that's another strong argument that a case should be expunged underneath the inherent authority. I think one thing with the settlement agreement is you need to look at the terms of the settlement agreement. Sometimes parties will sign a settlement agreement for the tenant to leave within 7 days, and that's it. That really isn't much of a bargain between the parties, but those settlement agreements that set up things like payment plans, and if they are making promises about fixing breaches, those types of things, that those settlement agreements, if they've been fully satisfied and the tenant stayed afterwards, I think they can be very important for a court to consider. Something else that's important to consider is whether or not the landlord, or the tenant still owes rent to the landlord. I can say particularly in Ramsey County, it is hard to get a case expunged if there's any money still owing to the landlord. It just has to deal with the jurisprudence of the bench in Ramsey. We don't see the same type of thing in Dakota, Hennepin, or Anoka County. We do see courts there that are willing to look more at the factors underlying non-payment and a more holistic view of the outstanding payment still made. It is important to note that even if a case is expunged, the underlying debt does not go away. So it is possible that a case could be expunged in a housing court, but then yet the landlord could still sue to recover any rent that was owed in conciliation court. Was the writ ultimately issued, or did the client leave willingly? I think this is important to note, and I think the idea of a writ, and when we give you the underlying paperwork of a case, you'll be able to see if a writ was issued, and you'll also be able to see if a writ was executed. There is a difference. The writ being issued means the court gave the sheriff the authority to remove somebody from, to forcibly remove a tenant, and an executed writ means that the sheriff actually had to remove them. I think when writs go all the way to execution, that it might look like there's some bad faith on the part of the tenant in staying until the very last minute. However, I think it's really important for us as the attorneys to have a conversation with our tenant to find out what was going on. Two things that I found is, the first thing is people pay rent. People just don't stop paying rent without a reason for doing so. And I think when we're interviewing our tenants and it's a non-payment case, it's upon us to find out what was going on with that tenant and what was the reason why rent was not being paid. I think it's also, when it comes to the issue of writs, that we need to talk to our tenant about why it went to a writ, what was going on. I can think of one really good example why someone might sit out to wait for a writ. One time I was counseling a client at the Housing Corp project, and the client had a family and wanted to get into family shelter because they needed someplace to live and they knew they could no longer afford the rent where they were. So we got on the phone, we talked to Hennepin County Social Services, and she was told that if she wanted to get into family shelter, that she would need to wait until she had the writ. And it was only when the writ was given to her that she would get priority to get into the family shelter. So it really put her in a difficult position and needing to wait out until she got the writ. But that would be something that I think should be raised in a justice argument. This case went to a writ because my client and her 3 young children wouldn't be able to get into shelter unless the case had been reduced to a writ. Another thing that we want to look at is the lack of opposition by the landlord. It's not uncommon when cases settle for there to be some sort of statement about expungement in that settlement agreement. Sometimes landlords will agree in that settlement agreement not to oppose expungement if the settlement agreement is satisfied. I think you can, once a settlement agreement is satisfied, if there's quiet as to opposition, I think you can still go ahead and file, but it certainly is a factor that weighs quite heavily in favor of a tenant if the landlord has agreed not to object in that settlement agreement. Another thing to look at is, did the client continue to rent from the landlord after the eviction? And this happens a lot. Someone's late on rent, the landlord files that eviction, the tenant pays up and the tenant stays. Did this tenant stay until the end of the lease? Did the landlord renew the lease for a period of time, even after the eviction happened? And if a tenant's on a month-to-month lease, every month that that tenant stays past that eviction is a month that that landlord is choosing to allow that tenant to stay. So, and if I think there's a good argument that the eviction does not adequately reflect on the tenant's ability to be a good tenant if the landlord who filed that eviction continues to rent from that tenant after the eviction happened and had the opportunity to have the tenant leave through an end of the lease or a month-to-month lease. Also, I think it's really important to know what has happened in the tenant's life between the time of the eviction and now. Once again, like I said, people pay rent. There is a reason why people stop paying rent. Sometimes it is death in the family, work lapse, broken vehicle, substance abuse issues, abusive relationships, all those types of things. So as you are looking at the eviction expungement, it's important to ask your tenant what was going on at the time of the eviction. Why weren't you able to pay rent? And then contrast those facts into what's going on in the tenant's life today. Did they seek treatment for substance abuse issues? Have they left the abusive relationship? Did they get a new job? Have they gone back to school? Was it a health issue that's no longer continuing? These are all things that are important to raise in your justice argument. Next slide, please. So if you've agreed to take a full rep eviction expungement case from us, or you're providing advice at our phone advice clinic and want to assist with the drafting, like I said, we're going to send you the underlying documents. Sometimes we don't have documents to send to you, and there's a pro and a con to that. The con is you're not going to be able to see the service documents and what the actual eviction complaint was for. But the pro is that the court has gotten rid of the case because it's so old, which I think really goes to the inherent authority argument, and the burden on the court is minimum in getting rid of the record at that point, but really that it's not important enough that the court even has that record any longer. Sometimes we are able to give a call to the courthouse, and there's some man in the basement at Ramsey who will pull up the records for us, and we can send them to you, and you can pull them out and we can convert them to a form that you can read. So sometimes we can get them, but sometimes they're just gone. We have all the blank forms that you need on our website. We're really working hard to streamline our volunteering process for our volunteers as much as possible. So we're going to have the motion forms, the IFP forms, all those forms that you're going to need to do the case will be available for you on the website anytime that you want, in addition to this training. When you're drafting eviction expungement motions, it's important to know that you're going to want to draft one motion for every eviction on a tenant's record. And it really is not uncommon for tenants to have more than one eviction on their record. For sort of the cycle of evictions we were talking about earlier, Matthew Desmond's book, which talks about how, it's once you get one, it's easier to get two. Another thing we see is we frequently see multiple evictions from the same landlord, sometimes 2, 3, 4. And usually what that means is that sometimes there's a variable paycheck or a variable ability to pay for a tenant. So they're being evicted for non-payment of rent on a serial, sort of one after another. And then it usually ends in the one that finally had them leave the property, or the tenant finally left the property. But it really is not uncommon to see more than one eviction. The other thing that we find that's not uncommon at all is people will come to us and they'll say, hey, I have one eviction on my record from 3 years ago. So we'll do the name search, and all of a sudden we'll see, oh, no, you really have like 4 evictions. And they'll be like, what? I thought I solved all of those. And once again, it goes back to that idea of eviction is on your record the moment it's filed. So it's not uncommon that tenants are surprised to see that they have more evictions on their record than they were even aware of. Also, with regard to one motion for every eviction, you need to do one IFP for every eviction. And this is because each eviction is filed into its original eviction, each eviction expungement motion is filed into the original eviction case, along with its separate IFP, certificate of representation, and proposed order if necessary. With regard to IFPs, if you are serving more than one tenant, which is also not common, which is also uncommon, you need to have one IFP for every separate household. So if you're doing a husband and wife who live in one household and share expenses, one IFP for the husband and wife that includes all of their income will be sufficient. But if you have 2 roommates who are sharing the space yet have separate jobs and essentially functioning separately, or have left so that they're no longer living together and really are in separate households, then you would need to do an IFP for each one. Also of note, courts do have the authority to grant an IFP simply based on the fact that you are a VLN volunteer and the tenant you are represented has been screened by us for income. We do ask that our volunteers fill out the entire IFP still, but it's really important to check that box that says that the client is being represented by a VLN attorney and that we've done some income screening beforehand. Next slide, please. About the process, like I said, documents for filing, it's going to do a notice of motion and motion to expunge eviction records, one for each eviction, same with an IFP and a certificate of representation and a proposed order. You don't need to file proposed orders in Hennepin and Ramsey County. It's because they have specialized courts which deal with expungements quite frequently, but anytime you're in any of the other courts in greater Minnesota, they don't do as many of these and really do appreciate having proposed orders. What you're going to want to do then is, because you're a licensed attorney, you're going to e-file all of your documents and you're going to e-file them all as confidential. Now, if you've never done e-filing before, we have some documents that explain both how to create account and how to do e-filing for an eviction expungement. Those are on our websites. We're happy to walk you through that too. I can tell you the first time through it seems a little awkward and tends to be a lot of questions, but hopefully our documents will have answered those. For those of you who are really uncomfortable in doing your own e-filing, we do e-filing for people sometimes, and if that's something that you're interested in, you can reach out to myself or Kate who grab the documents, and we can help you figure out a way to get some assistance getting those filed. Once you file, everything is confidential. It's going to be important that you file it confidential when you first do your filing because of that IFP, and that IFP should never be made public. It should always be kept confidential. And once the court issues an IFP order, so rules on that IFP, the court will then make the records public, and it's going to either assign an administrative review or a hearing date. This administrative review is new to this post-COVID time, and I think it's a positive change in court procedures, which we'll talk a little bit more about why that is. And then you want to make sure, and you're going to serve the eviction expungement motion and notice of administrative review or notice of hearing as required by the notice. And it's a relatively new process. Hennepin's been doing these for a couple months, Ramsey maybe a couple months too, Anoka is going to get started. But so you're going to want to read that notice carefully, and it's going to tell you how much in advance you need to make sure to serve people and when everything needs to be filed. Next slide, please. If it's an administrative review, and this is what I think is a positive change, because it used to be if you wanted to represent someone full rep, you had to file the papers and then you had to show up on a Friday morning or a Tuesday afternoon or a Wednesday morning, and you had to sit through an entire calendar, which could take a couple hours. But now what happens is when you file the paperwork, if the court deems the case to be reasonably non-controversial, what they'll do is just do an administrative review, which means that you'll have to serve the landlord, and the landlord will have so many days to file an objection to the eviction expungement motion. If the landlord doesn't file an objection after that administrative review date, the court will order the expungement based on the filings itself, or make a decision on the request just based on those filings. If the landlord does file an objection, the court then has the option to either go ahead and make the ruling on those papers itself or to schedule a hearing. And then when we go to the next slide. So if you get a hearing is scheduled, then hearings right now are via Zoom or via the telephone. They're scheduled for a specific time, and it's from your desk via Zoom or on the phone. And once again, you'll need to serve the landlord to make sure that they know, and they'll have the opportunity to come and make their argument at the hearing or file an objection beforehand once again. And the hearings, the ones that I have done so far, have not been long queues of waiting through many different tenants like we used to have, particularly in Hennepin County, but they've been relatively quick, a small number of cases. Couple notes on it: if you're using Zoom, make sure to enter early. You're going to want to make sure your tenant client has some way to also get into the meeting. Zoom tends to work fairly well for our clients. Calling in by phone is also an option. I want to make sure you have a way to contact the courthouse. If you have any technical difficulties during that hearing time, the notices of hearing should have a number that you can call if you or your client have any technical difficulties getting into the Zoom hearing. With regard to those hearings, the attorney role is generally very brief. It's just a brief opening statement about why this expungement should be granted. And then the judge, it's usually a very active judge asking questions. If you've been given a hearing, there's probably something that the judge wants to know. And it's been my opinion that for the most part, that the judge really wants to hear from the tenant, to hear a little bit about that tenant's story. Next slide, please. Post-hearing, something important to know is that you need to, if the expungement has been granted, you'll want to send a letter out to all the tenant screening agencies, letting them know that the eviction can no longer be reported. We have an example of the tenant screening agency letter on our website. It is hard to keep our tenant screening agency addresses up to date. So if you ever get any information or hear back from a bad address, we want to know that right away, because we do try to keep our tenant screening list up to date as possible. Next slide, please. I'm going to end here right at 1 o'clock, but just something I also want you to know when you're advising tenants on eviction expungements, that even with an expungement, that some of the effects of eviction do linger. I do have to say evictions still make a big difference in a tenant's life. It makes it a lot easier for tenants to apply for and receive housing, but there are some caveats that should be noted. And one of them is once what I said, that the debt is still owing to the landlord. And it still can be collected in conciliation court. And sometimes the filing of an eviction will be the poke at the landlord that will get that landlord to file that conciliation court claim. Doesn't happen very often, but it's just something that we want to make sure, particularly if there's larger amounts of money remaining to that landlord. Civil judgments and collection attempts will still show up on credit reports. So it's possible that while the eviction won't show up, that there might be something on a credit report that would show up. There still are the landlord references. Sometimes in settlement agreements, landlords will agree to a neutral or even a positive reference, but it is something that if the landlord might not give a positive reference, and that's not something that an eviction expungement will change. And then just all of the unregulated industries and data miners out there on the web. So with that, I have gone 1 minute over 1 o'clock. I know that we wanted to give the opportunity to ask questions. So what I'd like to do is, for those that need to leave, I certainly understand. For those people that do have a question and want to hang around for a few minutes, I'm happy to answer those questions. And then also my contact information is on the first slide, and we'll make sure that those slides are sent out to everybody. You're welcome to email or call with any additional questions that you have. We do have some eviction expungement cases that we're waiting to place with people. So if you would like to jump in and get started, we've got some cases for you. So once again, thank you to everyone who comes. I will hang around and answer a few questions if there are any questions that people have.
I do have a few questions here, Mariah. One is, can you talk about document retention schedules in Hennepin and Ramsey, and how the referees think about evictions that are beyond the applicable timeline?
Yeah, you bet. And there was a slide that had the document retention policy that applies to all Minnesota courts. So it's 1 year if there's no judgment attached to the case, and it's that the court may destroy the documents, and it's 10 years if there is a judgment attached to the case. Interesting about that judgment, the judgment doesn't mean that money is still owed. A judgment is when the landlord has gone to the additional step to docket that judgment into something that is collectible. So you really do, and there's going to be on the court docket that you will receive with the case, there will be a separate notation showing that a judgment has been docketed.
And is there ever a disadvantage in filing an eviction expungement motion? Assuming the request isn't completely frivolous, should you always go for it?
That's a great question. There is a slight disadvantage, but it's not, eviction expungement motions aren't granted or denied with prejudice. I guess maybe I've seen it once, but it was really when a tenant filed multiple eviction expungement motions and didn't ever get service correct. But no, you can file eviction expungement motions several times. And sometimes when an unsuccessful eviction expungement motion is filed, the court will indicate what needs to change so that the motion can be renewed. And sometimes it's more time. Sometimes it means that the tenant needs to reach out to the landlord to try to come up with a payment plan if money is still owed. At the same time, I don't think that you want to take extreme long shots with eviction expungement. Every time an expungement motion is filed, it's going to be part of the court record. So if an expungement is asked for at a later date, the court will be able to go back and see that one was asked for previously and is going to look at why that was denied. So I think some caution does need to be taken, but it's not as though an unsuccessful motion is going to make it so that a tenant could not bring another motion at a later time.
And have there been any general trends on rulings related to Steve Friend's properties in Minneapolis?
Oh, that's a great question. You know, I do think that particularly the referees that do housing court all day, every day, do know landlords that are slumlords or have more of a negative history. But at the end of the day, it is an individual look at each case. And I guess Friend's issue also had a license issue in the case. And if a property is not properly licensed, that is something that the court would look at. So it's still always an individual inquiry into each case, but it's certainly, it's something in the justice argument. If it was a Friend's property, you can put all of that into your motion and talk about why under the inherent authority, this is a particularly good case to grant an expungement for.
Does the tenant need to do anything to ensure service of the expungement motion on the landlord? And does it depend on the county?
Another really good question. The service that's required is the service is a motion, so it's simply mailing to the last known address of the landlord. There is, every landlord should have an address, and that address should be listed on the docket. If the address is not listed on the document, it's a business, you can look at the Secretary of State business webpage to see if they should have a registered agent address right there. But it really is just the last known address. So if you're taking an address that was off a court docket or off a lease that the tenant had, something like that, and sending off the letter, and it doesn't have to be effective service. It doesn't mean that they have to receive it. So we do get notices back that the landlord is no longer at that address, but the obligation of the tenant filing the motion is to simply serve it via first-class mail at the last known address for the landlord.
And finally, you mentioned a website that included guidelines on all defenses for eviction. Could you repeat the site?
Yeah, you bet. And that is also, it's if you search for Larry McDonough and poverty law, it will come up. I don't have a quick website for him, but Larry McDonough's Eviction Defense Manual is another one that would come up. And his website is fantastic. It's just a wealth of information, and people who are interested in getting more deep into eviction defense, it is the best place to go. His Eviction Defense Manual is essentially a treatise of Minnesota housing law. So if you ever have more specific questions about when you're getting way into the reads on an eviction defense, Larry's Eviction Defense Manual is the best place to start. All right, with that, just want to thank everybody once again for your time. We've gone a little bit over, and hopefully this training will give you the information that you need to pick up an eviction expungement case, give it a try, and get you hooked on doing housing law with us. Take care.